Thank you very much, Yvonne, and good morning, everybody, and a very warm welcome also from my side. As Yvonne indicated, over the next about 20 minutes or so, I will speak to you about what you need to do if you source chemical products from the UK. And in this session, first session this morning, I will be focusing, as Yvonne indicated, in particular on REACH, and especially looking at the requirements around REACH registrations and then a little bit on authorisations. So just to bring REACH into our minds, of course, it's an EU regulation. It entered into force back in June 2007. So most of us have been working with REACH for about 13 years now at this stage. REACH is an acronym, as many of you probably know. It stands for the registration, evaluation, authorisation and restriction of chemicals. And I guess when Brexit first came on all of our tables a number of years ago, we quickly realised and it quickly became apparent that most elements of REACH would be impacted by Brexit. And looking then to Irish companies, it quickly became apparent also that the main impact would be around registration, and that is coming to the fore, with some impacts also on authorisation. So that's the reason, I suppose, this morning that we're going to particularly look at registration and also on authorisation. The timelines that we are speaking about, I'm sure you're well aware of them at this stage, Minister English, just let us know that there are 77 days to go to the end of the transition period, which of course is the 31st of December this year. And when we're looking this morning at any implications that we're talking about with respect to yourselves as companies and then to the substances that are placed on the market from the UK, we're really talking about the 1st of January 2021. So that's the date that all of us need to keep in our minds at the moment. So before I get into it, just a quick reminder around the roles under REACH, because really what role you have in the supply chain and what actor you are with respect to REACH will determine what obligations you have. And just to remind us, because as I said, a lot of us have been working with REACH for many years now, so it could be a while actually since you've thought about your particular role or your particular obligations. And perhaps for some of you online with us this morning, it could be the first time, maybe with Brexit coming, that you've had to think, what is my role here and what do I have to do? So a quick look then at the roles. All of the EU companies, so we're talking about EU-based companies. A manufacturer is a company that simply manufactures the substance. An importer is the company who is responsible for importing that substance into the EU. And then an EU-only representative. And this is something that will come up throughout the presentation this morning. An only representative is a company in the EU who is appointed by a non-EU company, and they fulfill the obligations of the EU importers. And indeed, many of you may be working under the registrations of only representatives at present. I have put an asterisk beside each of these first three actors because these are the people in the supply chain who have to register under REACH. And then, of course, we have downstream users who use substances during their industrial or professional activities, and we have distributors who simply store and place a substance on the market. So hopefully you know at present what role you have within the supply chain under REACH. And it's very important to know this because, of course, the roles will change as of the 1st of January 2021. And that will become apparent to you, hopefully, as we move through the presentation this morning. At the moment, you are a downstream user or a distributor if you source chemicals in the UK. So there's no asterisk beside your name in the above list. But you will become an importer in January 2021 because you'll be sourcing from outside the EU at that stage. And of course, with that change in role will come new obligations. And that's really what we're going to focus on this morning. And hopefully, as I said, it'll become apparent as we move through the presentation. Before we get into it, I just want to speak very briefly about the Ireland-Northern Ireland Protocol. And Yvonne mentioned it briefly before we began. But it does have some implications as to what we're speaking about. We know that the protocol makes certain provisions of EU law, including REACH, applicable also to and in the UK in respect of Northern Ireland. And this means that substances that are made in Northern Ireland or imported into Northern Ireland from outside the EU, a greater than a tonne per annum, must be registered by that Northern Ireland company. So they need to be in compliance with REACH because REACH applies in Northern Ireland or will apply in Northern Ireland. And these include substances that are sourced in England, in Scotland and Wales, which we will refer to as Great Britain from here on. Substances that are shipped to the EU, so maybe to Ireland here, from Northern Ireland, are not subject to REACH registration requirements on entry into the EU because REACH applies in Northern Ireland. So that would mean that if an Irish company is sourcing substances from Northern Ireland, they're not deemed to be importing from outside the EU. So they're not an EU importer. So the flow of substances can come from Northern Ireland into Europe without the need for REACH registration. And just so that you know then, for the remainder of the presentation, the responsibilities that I'll speak about on Irish companies from the 1st of January 2021 refer to substances that are sourced in Great Britain, not in Northern Ireland. So we're talking about substances that you may buy in England, in Scotland or in Wales. We've spoken already about import, and certainly with Brexit and after Brexit, import and placing on the EU market will become more of an issue for Irish companies. And just to remember, the import means the physical introduction into the customs territory of the EU. And who is the importer and the responsibility for import can depend on many factors. It could depend on things like who orders, who pays, who's dealing with custom formalities. So certainly from speaking to companies on our chemicals help desk in recent months, it is not always as clear-cut as it might seem as to who is responsible for import and who the importer actually is. And this is something that all companies may need to consider. It may be straightforward. It may be just a simple case of ordering from a company in England, and in that case you are the importer. But just bear in mind, it may not always be simple. And to give you an idea of what we're speaking about here, to give an example of a sales agency, which is established in Ireland, and we've come across a number of these, or indeed in any EU 27 member state. And this agency acts as an intermediary between the Irish company that's buying chemical products in Great Britain and the supplier in Great Britain. The sales agency, as part of its business, it transmits the order from the Irish buyer to the supplier in Great Britain. Now, that sales agency doesn't necessarily choose the supplier in Great Britain from whom to order the goods. The Irish company decides who they want the goods from. So the sales agency does not take any responsibility for the products or for the payment indeed. So in that regard, that sales agency is not considered as the EU importer under REACH. And they don't have any responsibility for the physical introduction of the products into the EU. So in this case, the Irish company, the Irish buyer, is the EU importer and would be responsible for registration. So now let's take a look at registration itself, and I suppose to remind ourselves, for those of us who have been working with it for a while, and perhaps for those of us online today who might be new to this, in general, REACH registration requires that a substance, now we're talking about substance, which can be on its own, it can be in a mixture, or indeed it can be in an article with intended release, that's made in the EU or imported into the EU at greater than a tonne per annum must be registered. That's really the starting point. There are, of course, exemptions, maybe for like medicinal products or food, because they're regulated with other regulations, but in general, this is the starting point for registration. I've put up some statistics here around the REACH registrations that are in place in the UK at present, and it's become apparent as to why we've put up these. At the moment, there are just under 9,000 registrations, REACH registrations, still in place by UK companies. And this number used to be bigger, of course. I think it used to be up around 14 or 15,000 or maybe even more, but a lot of them have moved getting ready for Brexit. But there are still almost 9,000 REACH registrations in place in the UK. I have an asterisk beside that because at the moment we are assuming, and it is probable that this also includes REACH registrations that are in Northern Ireland. We don't know the breakdown between Great Britain and Northern Ireland at the moment. I actually have a query in with the agency in Helsinki on that at present. But we can probably safely assume that the vast majority of those almost 9,000 are probably in England, Scotland or Wales. And looking at them, 40% of those registrations have been made by UK importers, 30% of them by manufacturers, and a quarter of them, 25% of them, have been made by only representatives that are based in the UK. And why it is important to look at these statistics is the fact that we know that many Irish companies may be relying on these registrations in Great Britain for their own supply, including those made by the only representatives based in Great Britain. And indeed, many of you online today could be relying on a REACH registration that is either made in the UK by an importer or manufacturer or by an OR based in Great Britain. And why this is really important, of course, is that come January 2021, these registrations in Great Britain will be void and the Irish companies can no longer rely on them. So that's probably the scenario that is facing some of you online today, and indeed many companies around the country. So having a look at the impacts then on Irish companies with respect to registration and just what we've spoken about, let's look at what's currently in place. If an Irish company buys a chemical from a supplier in Great Britain for their own use or further distribution, their role under REACH is downstream user or a distributor, and they don't have any registration obligations because they're sourcing in the EU. And many of you online today are probably currently in that situation. However, come January 2021, if the Irish company buys the chemicals from a supplier in Great Britain, their role under REACH changes to an importer because they are now buying from outside the EU. And with that change in role, as I've said already, will come registration obligations. What I'm going to do in the next few slides is just to look at some scenarios that we know Irish companies are finding themselves in, and then what the options are for the Irish company and indeed for the supplier in Great Britain in order to alleviate the situation as such and to ensure the continued legal placing on the market of the substance. As we move through these slides, maybe just have a look at them and see, can you find yourself in the scenario that we are speaking about, and then take note and consider the options that are there. So the first scenario is where an Irish company buys a registered substance from a registrant based in Great Britain. So it might be one of those manufacturers, the 30% or the 40% of the importers, or indeed an only representative. So you're getting a registered substance from a registrant in the UK. And as I said, the Irish company does not have any registration obligations at present because they're a downstream user, they're sourcing in Europe. Come January 2021, as I said, the Irish company cannot rely on that registration in Great Britain anymore as regards the legal placing of the substance on the EU market because the registration is void. So looking to the options then, the first options are, there's options available, of course, to both the supplier in Great Britain and into the Irish company. And looking at the options that are available to the supplier in Great Britain, the first options there, and we know these options are happening at the moment. We know some of them, we know they have happened, and we know that a lot of companies in Great Britain are actively working on these options. The supplier can move the operations, so move the manufacturing operations or the importing operations to a company, a legal entity based in the EU27 or in the European Economic Area. And of course, that's Norway, Liechtenstein or Iceland. And to complete a legal entity change, the registrations are transferred over and the supply can continue. If the supplier in Great Britain is a manufacturer, but not an importer, and that's an important nuance to remember around ORs. If they are a manufacturer of the substance, so if they belong in the 30% of the registrations we spoke about, they can appoint an only representative in the EU, and they can transfer their registrations to that only representative. So the registrations are then in Europe, they've been transferred over, and the supply can continue. And in both of these scenarios, the Irish company still has no registration obligations because they are still sourcing within Europe and the REACH registration is in place. I did point out about the only representative and the appointment of the only representative. It is important to remember, if you're speaking to your supplier in Great Britain, that only manufacturers and formulators of mixtures that we'll come on to in a minute, but manufacturers can appoint an only representative. A supplier in Great Britain who's an importer can't appoint an only representative. It's just the way REACH is written. For the Irish company then, the Irish companies of course have options around this. The first and foremost option is that they use another supplier in the EU, move away from the supplier in the UK and move to a supplier maybe in France or Germany. I fully appreciate and we fully appreciate that that isn't and may not be as easy said as done for various reasons, but that probably should be the first port of call as such. The Irish company can continue buying from the supplier in Great Britain. There's nothing to say you can't, especially if the supplier hasn't availed of either of the options that we spoke about above, and the Irish company can register under REACH as an importer. Now, registration under REACH, and for those of you online this morning who have done it, it may not be the easiest job in the world to do, and it can be a job for life. And it probably, for maybe smaller companies around the country, this could be the least favourable option. So certainly the other options should be explored first. But if you find yourself that you are in this position, you are buying registered substances from a registrant in Great Britain, consider what your options are now. Talk to your supplier in Great Britain about their intentions post-Brexit, because it could well be that they are looking at a couple of the options, one of the options that we spoke about above. We have spoken a lot about only representatives, and we get a lot of queries to our help desk on only representatives from Irish companies about only representatives being set up to do the registrations, etc. And I've outlined a scenario here which is likely to be quite real, in that an Irish company purchases substances in China, and that Irish company is relying on the registration of an only representative who's based in Great Britain. And a lot of you might be in this situation. So currently then what we have is that the Chinese manufacturer has appointed an only representative in Great Britain. That only representative has carried out the registration, supplies on to you in Ireland, and you are covered by the registration of the only representative, and you're a downstream user. No registration obligations, everything is fine. However, and you'll probably see the pattern emerging now, come the 1st of January 2021, that only representative in Great Britain will no longer be legally established in the EU, and it's a requirement that ORs have to be legally established in the EU, because of course Great Britain would be not in the EU. So their registration, like any registration, will become void at that stage. And of course then the Irish company can no longer rely on the registration of the only representative. And as before, there are a number of options available, both to the only representative who can move to the EU 27. And we do know from speaking to companies through the help desk, particularly only representatives in Great Britain, that they are moving to Europe. Some of them are moving here to Ireland, and they're bringing their registrations with them. The Chinese manufacturer, of course, could appoint a new only representative based in Europe. So he will forget about the only representative he has appointed in Great Britain, and he'll appoint a new only representative in Europe to keep the registrations in Europe. And the registrations will then be transferred from the guy in Great Britain over to the new OR in the EU. And again, in both of those cases, the Irish company has no registration obligations because they are sourcing within the EU from an EU legal entity. The final option for the Irish company, and the only one really, is that the Irish company imports from China and registers as an importer. But again, as we've spoken before, this is a relatively difficult option, and other options should perhaps be explored first. It's certainly doable, but something that companies will need to consider. So again, if you are dependent on an only representative based in Great Britain, and you will know if this is the case, if this is your supply chain, speak to the only representative now, or perhaps speak to your non-EU supplier to determine their intentions post-Brexit. Because as I said, it could be a case that the non-EU supplier is intending to appoint a new only representative. And we see new ORs being appointed all the time and move the registrations across. We have spoken a lot around the various options, particularly for the companies in Great Britain, of course, and the only representatives transferring their registrations to the EU and moving to the EU. And there's a huge amount of activity, I guess, in that area. So just a couple of things that companies need to be aware of in that regard. The new legal entity in the EU cannot be set up on paper only. And this is something that emerged quite a while back. It has to be the result of a legal entity change. And what we mean here is that the company in Great Britain might go through an acquisition or an actual relocation to the EU. Or perhaps there's an intra-group transfer of the activity. And the activity here we're talking about is the manufacturing activity or the importing activity connected to the registration. So the activity is transferred to the EU. And an example here, of course, would be that you get the transfer of the manufacturing from a mother company based in Great Britain to a daughter company based in the EU. And the company that's in Great Britain must cease their manufacture or import until after the transition period if they have done this legal entity change, because they've moved their registrations. The changes must be notified in REACH IT to the European Chemicals Agency before the end of transition period, and the agency has a lot of guidance on its website as to how registrations can be transferred and how all this happens. And important to remember as well, and particularly this is linked to the first point above about the company not being able to set up on paper only, is that responsible staff and relevant documentation must be available to the EU enforcement authorities at the premises of the registrant. So it can't just be on paper or a PO box. It must be a company to which we can call. Okay, so what we have just spoken about is Irish companies sourcing registered substances from a registrant based in the UK, and many of you online today will probably be in that situation. What I want to move on to now, and it still relates to registration, is the area where Irish downstream users and distributors are buying mixtures from formulators in Great Britain. And I would reckon that more of you online this morning are probably in this situation, perhaps, than those of you getting registered substances from Great Britain. Because we do know that many Irish companies buy their mixtures in Great Britain. And those mixtures are just formulated. They're mixed in Great Britain. So as we did before, let's have a look at what is the current situation. The formulator in Great Britain, he doesn't have any registration duties for the substances they use in their formulation if they buy them in the EU. So they're buying them in the EU, they're mixing them into the formulation, and they're selling on the mixture. So they don't have any registration duties because they're sourcing in the EU. The Irish downstream user or distributor doesn't have any registration duties for the substances in the mixture because they're buying them in the EU from the formulator. So in this way, these substances, there's no registration duties either in Great Britain or Ireland at the moment. However, come January 2021, the company in Great Britain will become a non-EU formulator, so they're out of the EU, and the Irish company will become an importer and potentially has registration duties of the substances in the mixture. So this is a really big change for those Irish companies that are bringing in mixtures from Great Britain. No registration duties on either the company in Great Britain or in Ireland. And suddenly the Irish company will find themselves with registration duties. So what do you do? There are a number of options, as we've spoken about before, both for the formulator in Great Britain and for the company in Ireland. The formulator in Great Britain, because they're a formulator, formulators and manufacturers are allowed to appoint only representatives. So that formulator of the mixture in Great Britain could appoint an only representative in Europe to complete the registrations of the substances. And in this scenario, the Irish company, of course, still has no registration obligations because they're sourcing in Europe. The Irish company can try and buy the mixture from another EU supplier. That's, as before, your first port of call to see can you buy it somewhere else and stay within Europe. Or you can continue to buy the mixture from Great Britain and register the substances in the mixture. If you are in this position, and I would bet that probably a lot of companies online this morning are probably in this position, you need to consider your options now if you haven't already done so. Certainly talk to your supplier in Great Britain about their intentions post-Brexit. But there might be a small bit of good news as such in relation to this. And I have spoken to many companies in recent months about an exemption under REACH for re-import. It's under Article 27C of REACH, and this could well apply. And this is something that companies certainly need to take note of and to consider. As I said, there is an exemption under the REACH regulation for re-imported substances. And this applies to substances that are registered in the EU, exported out of the EU, maybe to be formulated or packaged or something, but not changed, re-imported back into the EU again, chemically unchanged within the same supply chain. There are a number of conditions that need to be met for this exemption. They're not too onerous. The substance must be registered before it's exported, so it must be registered in the EU by the person who manufactures or imports it. The substance, and this is very important, that's exported and re-imported must be the same, and it must proceed from the same supply chain in which it was registered. And the re-importer must be provided with certain information on the substance, perhaps such as a safety data sheet. From speaking to companies, it has become apparent that this could be a real option for Irish companies sourcing formulated mixtures that are formulated in Great Britain. The Irish company could indeed be seen as the re-importer of substance in the mixture, and hopefully the next scenario will explain this. The scenario we're looking at is where the formulator in Great Britain sources their substances in Germany, and they supply a mixture onto an Irish company. So the substances are registered by the supplier in Germany because he has to register them. He's either making them himself or he's importing them. He exports them so the supplier in Germany exports the substances from Germany to Great Britain. So they're going from the EU, out of the EU to Great Britain. The formulator in Great Britain prepares the mixture. They don't chemically modify the substance in any way. They just put 2 or 3 substances together, mix them up into a mixture, and then the Irish company buys that mixture from the formulator in Great Britain, and they re-import the substances into the EU. Because in this case, the substances are registered in the EU, they're exported out of the EU, they're just mixed, they're not changed, and they are re-imported back into the EU again. So the exemption from registration, and you've got to remember that the Irish company at the end of the line is the person who could potentially have the registration duty for the substances, and the exemption from registration could apply to the Irish company. So we would certainly encourage companies finding themselves in the situation to talk to their supplier in Great Britain and determine if they source EU-registered substances for the mixtures that they supply into Ireland, and gather your evidence then around being able to meet the exemption. Okay, so that's registration covered. I just want to touch on a couple of other things. We do get asked quite often around substances already on the market. So I said I'd mention this morning. If substances are imported from Great Britain into Ireland up until the end of this year, they can be used and they can be further supplied after this date without the need for registration by the Irish company. But just to note that the substances must be already physically on the market by that date. So they can't be in storage in the UK, or maybe you've just placed the order and you're waiting for them to come in. Because as of January then, any substances that are imported for the first time from Great Britain into Ireland must be registered before they can be placed on the market. Okay, that's registration. I'm going to turn my attention now to authorisation. You might be glad to hear that the authorisation section is a lot shorter than the registration section. But just to, like we did with registration, to kind of bring our minds back to authorisation and to take it back into the room as such, to remind us as to what it's about. In accordance with authorisation, a manufacturer, an importer, or a downstream user may not place a substance on the market for use, or they can't use it themselves after a certain date, it's called the sunset date, if the substance is subject to authorisation. And a company who applies for an authorisation can do so for their own use and the uses of their downstream users. And that's probably the most important thing when we're thinking about Brexit, is the uses of the downstream users. Because we know that there are companies in Great Britain that are authorisation holders, and that Irish companies who are downstream users, they may be using substances under that authorisation in Great Britain. It is likely, I think, that many of you who are online this morning will not be in this situation, maybe not so much as reach registration, but if you are in this situation, then you know who you are as such, and there could be implications, or there will be implications indeed for you. So just to briefly look at those. As with the registrations, when it comes to January 2021, authorisations that are held by companies in Great Britain will not be valid. There are a number of options for the companies in Great Britain. They can transfer their authorisation to an only representative, as we did with the registration, and this can only happen after the end of the transitional period. And as before, it just, of course, applied to the importers. They can transfer their authorisation to an EU manufacturer or importer or downstream user of that substance under the authorisation, and they must do this through a legal entity change. The only representatives in Great Britain, of course, also have authorisations in place, and the same thing very much applies to them, and they can transfer the authorisations before the end of the transition period to an OR based in the EU in the same way as they did with the REACH registration. So again, it's about transferring from Great Britain to an EU legal entity. If you're an Irish company online this morning and you are relying on an authorisation granted to a company in Great Britain, your options are to find an EU supplier with a valid authorisation and that will cover your use under that authorisation, or indeed apply for an authorisation yourself. And again, as with the registration, that is quite an onerous task, but is something that companies may need to consider. So as with others, if you are a downstream user here and you are covered by an authorisation of a supplier in Great Britain, you definitely need to speak to that supplier now to determine their intentions post-Brexit and put your preparations in place. I'm almost finished, but before I do, I just want to give a small little bit of information as regards UK REACH. Of course, we've only been talking about EU REACH because that's what's going to concern us here in Ireland. But of course, at the end of the transition period, EU REACH will be brought into UK law under the European Union Withdrawal Act. So this means that come January 2021, UK REACH regulation and EU REACH regulation will operate independently from each other. And there will be REACH registrations in the UK. They will exist in Great Britain, as the EU registrations will exist here in the EU. And if Irish companies are exporting substances to Great Britain, you really will need to ensure that there is a UK REACH registration in place. Now, there are different timelines for these registrations. I do know that the UK companies have 300 days initially to give certain information as regards to registration to the UK authorities, and then there are staggered registration deadlines of, I think it's 2, 4 and 6 years after that. They've been recently extended to allow UK industry more time. And as non-EU companies can appoint an OR in Europe, Irish companies will be able to appoint an OR in Great Britain after January 2021. If you are exporting to Great Britain and you want a company to act on your behalf in Great Britain for the registrations. I'm not going to go into any more detail here on this, but if you do want further information and it is something that interests you or may impact you, there is good information and guidance on the website of the HSE at that link. So that comes very near the end, but just, I suppose, a few sum-up points if you are just to take home with you around preparing for Brexit. You really, and with 77 days to go, it's probably very urgent now, and hopefully you have done it before this, but you definitely do need to examine your current supply chain and know if you're sourcing substances from a supplier in Great Britain. And if you're a downstream user, are you relying on an only representative based in Great Britain? Perhaps you're reliant on an Irish distributor who in turn sources from Great Britain. You need to have a chat with them and see what they're doing. You may be reliant on an authorisation that's granted to a company in Great Britain. Ask yourself, can you change your supplier to an EU 27 one? That rules out all of the issues and problems and ifs and buts and maybes that we've spoken about. And it's a serious thing to certainly consider, but as I said, easier said than done. And if all that fails, or you might just want to go ahead with it, are you in a position to take on the role of the EU importer if you continue to source in Great Britain after January? And very importantly, do speak to your suppliers in Great Britain or the only representatives to determine what their plans are, because they could be putting a lot of those options in place that we spoke about. And just to remind you that there are a lot of supports available. I know the Minister already indicated this, but we run our Chemicals Help Desk. We are certainly here to answer your queries on Brexit, chemicals@hsa.ie. Our web pages, European Chemicals Agency has a lot of information on Brexit on their web pages, including questions and answers. The Minister indicated the European Commission notice on chemicals. It goes through actually a lot of what we've spoken here today. And of course, the supports that are available around the country from the government departments and from the agencies. And with that, I would say thank you very much for your attention. I know we're going to take some questions now, but if we don't address what you have or you've got a longer question, of course, don't forget to email them to our website or our help desk, chemicals@hsa.ie. Thank you very much.